So a trial is where the dispute gets decided, where each party has an opportunity to put their evidence before a decision maker. The way that a trial works is that first the plaintiff goes up, they say their opening statement, and then they get to call the witnesses to submit their evidence. The other party's lawyer, so the defendant's lawyer, will have an opportunity to cross-examine the witness of the plaintiffs to scrutinize their evidence. Then the inverse happens. The defense gives their remarks, they present their evidence, and the plaintiff's lawyer has an opportunity to cross-examine the witnesses of the defendant. There are different kinds of witnesses that parties can call to submit their evidence. There's what's called an ordinary witness, which is somebody who we ask to recall their memory from firsthand experience of what happened. The witness's responsibility is to give honest, firsthand information. If a witness starts talking about second or third hand information, my sister told me this, my best friend said he was wearing this, I heard on the news that they were doing that, that's what we call hearsay. And it's not admissible evidence because it's not good evidence if it's not firsthand. It's the judge that gets to decide which evidence is and isn't admissible. And so when you see lawyers jumping up on TV objecting to things and a judge staying the objection or overruling the objection, that's the judge saying, you're right, that evidence won't be admissible, or sit down, counsel, this evidence might be admissible. On the other hand, we have expert witnesses, and we want from expert witnesses what we don't want from ordinary witnesses, and that's their opinion. Not just their opinion on anything, we want their opinion in the specific area where they have been certified by the court to be an expert. So you can't just throw anybody up and call them an expert. There is a process to scrutinize their credentials and make sure that we have true experts on the stand. Having said that, it's frequent that both sides will call opposing experts who are both certified, and then we end up having to decide which expert we find more credible or believable. Once both sides have presented their case, then each party will give their closing statement to summarize their position and their evidence, and the judge or judge and jury takes the information away to make their decision.